There are moments in American political life when a single ruling, a single decision, a single line in a Supreme Court opinion lands like a thunderclap, and you can almost feel the political ground shift beneath your feet. What is happening to the Democrat Party right now in front of the United States Supreme Court? The systematic dismantling of its preferred legal theories, the rejection of its constitutional arguments, the humiliation of its lawyers in oral argument after oral argument, none of it surprises me, not one bit. Because when you build an entire political movement on the premise that the courts exist to deliver outcomes you cannot win at the ballot box, eventually the court remembers that it is a court. And when it does, it doesn't matter how many law review articles your allies have written, how many sympathetic profiles your nominees received, how many times the legal commentariat assured you that your arguments were obviously correct. The Constitution has a way of settling the score. Let's go back. Because to understand the scale of what is unfolding right now, you have to understand where it started. June of 2022. The Dobbs decision. The Supreme Court returns the question of abortion to the states, where it had always constitutionally belonged, and the reaction from the Democrat Party was not the reaction of a political movement that disagreed with a legal ruling. It was the reaction of a movement that had just been told the rules apply to them too. Chuck Schumer stood on the steps of the Supreme Court. He named justices by name. He warned them they would, quote, pay the price. He said they wouldn't know what hit them. The Senate Majority Leader of the United States, standing in front of the highest court in the land, threatening federal judges. And the press, the great guardians of democracy we keep hearing about, treated it as a passionate moment. A few weeks later, an armed man showed up at Justice Kavanaugh's house with a plan to kill him. And still, the rhetoric did not stop. Still, the court packing schemes kept coming. Still, the calls to impeach justices, to expand the bench, to ignore rulings, to strip jurisdiction, kept multiplying. That was the tell. That was the moment you could see exactly who the modern Democrat Party had become. A party that views every institution it does not control as illegitimate by definition. And here is the part of this story that the press will not tell you honestly, even now. For years, the legal commentariat in this country, the law professors, the cable news analysts, the Sunday show regulars with their tasteful glasses and their measured tones, functioned as something closer to a public relations firm for the progressive legal project than as honest analysts of constitutional law. Every time the Supreme Court took up a case involving administrative power or executive overreach or the limits of federal authority, the commentariat assured the audience that the conservative position was fringe, extreme, outside the mainstream. Any decision that went the wrong way was framed as activism. Any decision that went their way was framed as the natural application of settled law. Millions of Americans went through year after year of this coverage without ever getting a clear-eyed accounting of what the Constitution actually says or what the court was actually doing. Well, we're getting that accounting now. And for the Democrat Party, it is not pretty. Let's talk about the recent term. Let's talk about what has actually happened inside that marble building over the last several months. Because the picture that emerges is the picture of a political party whose legal arguments are being rejected so consistently, so emphatically, and on such fundamental questions that you have to ask whether the party even has a coherent constitutional vision anymore. The administrative state cases, that whole architecture of unaccountable bureaucratic power that progressives spent 50 years constructing, is being dismantled brick by brick. The Chevron doctrine, gone. The premise that unelected agency officials could effectively make law by reinterpreting statutes, rejected. The major questions doctrine, strengthened. The non-delegation principle, revived. Every single one of these moves represents the rejection of a legal theory the Democrat Party had embraced as obvious, settled, and beyond serious dispute. They were not obvious. They were not settled. They were political preferences dressed up as constitutional commands. And the court has now said so out loud. Then there's the executive power question. For years, when a Democrat sat in the White House, The legal commentariat assured us that broad executive action was a necessary response to congressional gridlock. Student loan forgiveness by fiat, immigration policy by memorandum, climate regulation by reinterpretation, mandate after mandate, order after order, all defended as the legitimate exercise of presidential authority. And then the court began saying no. The student loan forgiveness program struck down. The eviction moratorium struck down. The vaccine mandate for large employers struck down. Each ruling a quiet, methodical reminder that the President of the United States is not a king, that Article 1 vests legislative power in Congress, and that the executive branch cannot rewrite the law because the legislature will not. These were not close cases. These were rulings that essentially asked the administration, where in the Constitution does it say you can do this? And the administration had no answer. Because there is no answer. Because the power they claimed never existed. And who paid the price for all of this? Let's be honest about the collateral damage. Because the Democrat Party did not just lose legal arguments in the abstract. Real people built real lives around the assumption that those legal theories would hold. The administrator who designed her career around an agency that turned out not to have the authority she thought it had. The borrower who was told his debt would be forgiven and then found out the President of the United States did not have the constitutional authority to forgive it. The small business owner buried under regulations imposed by agencies that the court has now said exceeded their statutory mandates. The voters in the middle of the country who were told for years that the constitutional order was secure, that the experts had it under control, that nothing was changing, only to discover that almost everything about how their federal government had been operating was being held together with legal duct tape and the willingness of judges to look the other way. Those voters rendered a verdict in 2024, and the legal verdict is being rendered right now, ruling after ruling, opinion after opinion. The architecture of progressive governance is being audited in real time, and the audit is brutal. Now let's talk about what has emerged just this term, because this is the chapter that may end up defining the Democrat Party's relationship to the judicial branch for a generation. In the last several weeks, in oral arguments and in opinions handed down from this court, we have watched the Democrat Party's legal positions collapse on questions ranging from the scope of nationwide injunctions to the limits of agency rulemaking to the constitutional status of independent regulatory commissions. The Solicitor General's office under the previous administration spent its final months in court defending positions that the justices, including some of the more moderate ones, found nearly impossible to take seriously. Lawyers walked into that courtroom believing the prestige of their office would carry the day and walked out having been asked by justices to identify, in plain text, where exactly in the Constitution the authority they claimed could be found. Over and over, the answer was, in essence, well, we have always done it this way. And the court replied, in essence, that is not a constitutional argument. That is an admission. Now I want to be precise here, because precision matters. Some legal analysts on the left have argued that these rulings are narrower than the headlines suggest, that the court has not actually overturned as much as critics or supporters claim, that the practical effects are limited. That's a fine technical distinction if you want to make it. But here is what is not a fine distinction. The intellectual foundation that the Democrat Party has rested its governing strategy on for decades, the idea that the federal bureaucracy can fill in whatever Congress leaves unfilled, that the executive branch can act whenever the legislative branch will not, that the courts will generally defer to expert agencies on questions of policy, has been comprehensively rejected at the highest level of the American legal system. Whether every single doctrinal nuance has been formally overruled does not change what has happened. The presumption has flipped. The default has changed. And every Democrat lawyer who walks into that courtroom from now on is walking in on hostile terrain. Not because the justices are partisan, but because the arguments they have been trained to make rest on premises the court no longer accepts. And the pattern runs through everything. You saw it in the Second Amendment cases, where the Democrat Party's argument essentially boiled down to the proposition that a constitutional right could be regulated out of existence as long as legislators believed they had good reasons. The court said no. You saw it in the religious liberty cases, where states and municipalities tried to push religious organizations out of public life under the cover of neutrality, and the court said no. You saw it in the free speech cases, where the federal government's coordination with social media platforms to suppress disfavored viewpoints raised constitutional questions that the legal commentariat insisted were trivial, and the court took them seriously. You saw it in the election law cases, where the so-called independent state legislature theory was supposedly an extremist fringe position until the court engaged with it seriously and constrained it on its own terms rather than dismissing it as the commentariat demanded. Each of these cases on its own might be defended. Taken together, they form a portrait of a political movement whose constitutional instincts have been wrong, repeatedly, on issue after issue, and whose response to being wrong has not been reflection but rage. Here is the thing about the modern Democrat Party that its defenders have never been able to fully process. The gap between its rhetoric about norms, institutions, and the rule of law and its actual conduct toward institutions it does not control is not incidental. It is structural. It is baked into who the party has become. This is a party that lectures the country about democracy while attempting to abolish the Senate filibuster the moment it has the votes. A party that talks reverently about the sanctity of the courts when the courts agree with it and openly contemplates packing them when they do not. A party whose senators leaked draft opinions, doxed clerks, harassed justices at restaurants and outside their homes, and then stood in front of cameras and asked, with straight faces, why public trust in the judiciary was declining. It is the conduct of a movement that genuinely believes the only legitimate institution is the one currently delivering its preferred outcomes. And when you build a movement on that premise, you do not get to be surprised when serious people on the court stop pretending you are arguing in good faith. If you wanted a single physical monument to this collapse, you could not do better than the failed federal courthouse expansion in Washington, the proposed annex that was supposed to house the additional justices a future Democrat Congress would supposedly add. Architects were consulted, op-eds were written, foundations were established to push the plan, and year after year the proposal sat there, gathering dust, becoming a punchline, because even the party's own senators could not agree on whether to actually do it. It was a monument to threats that could not be carried out, to fury that could not be channeled into law, to an entire political project that could imagine destroying an institution but not building anything to replace it. The blueprints exist. The political will does not. That is the Democrat Party's relationship to the Supreme Court in a single image. Endless rage, endless threats, endless commentary, and no actual capacity to do anything except watch ruling after ruling come down and complain about it on cable television. And I want to pause here because this matters. There has been, over the last year, a real and disturbing campaign of personal harassment directed at individual justices and their families. Protesters outside private homes, threats made against children. In one recent incident, a sitting state attorney general from a deep blue state made public comments about a justice that were so far over the line that even his own party distanced itself within hours. That was wrong. It was beneath the dignity of any American who claims to care about the rule of law. And I say that without hesitation, because it needs to be said. You can believe that the Democrat Party has been intellectually and politically humiliated by this court and still believe that the men and women who sit on it deserve to live in safety, to raise their children without fear, to do their work without being stalked. Those two things are not in conflict. The justices are not piñatas. They are public servants doing one of the hardest jobs in American government, and they deserve the basic respect owed to anyone serving in the constitutional offices of this country. But here is what that episode also tells you about the larger story. The derangement that the loss of court control has produced inside the Democrat Party, the way it has corroded the party's relationship to law itself, the way it has pushed its activists from disagreement into something closer to revolt, is now part of the party's identity. Senators threatening justices, activists picketing their homes, law professors writing essays arguing the court has lost legitimacy whenever it rules in ways they dislike, state officials hinting that they might simply refuse to enforce certain federal rulings. These are not the actions of a confident political movement. These are the convulsions of a movement that has lost the argument and cannot accept it. I want to address something directly because I know how these conversations get framed. Criticizing the Democrat Party's behavior toward the Supreme Court is not about partisanship. It never was. For those of us who have watched this slow-motion collapse with our eyes open, the failures are not ideological. They are institutional. A party that cannot persuade 9 lawyers in robes that its constitutional theories make sense has not been victimized by extremism. It has been out-argued. A party that responds to being out-argued by threatening the arguers has not been treated unfairly. It has revealed itself. The irony of history, and history is full of ironies, is that the Democrat Party's own conduct over the past several years has done more to expose the weakness of its legal positions than any conservative legal scholar could have done. Time has a way of doing that. The administrative state precedents have collapsed. The deference doctrines have collapsed. The expansive executive theories have collapsed. The court-packing crusade has collapsed under the weight of its own embarrassment. The campaign to delegitimize individual justices has collapsed into a national security problem. The Democrat Party was given every advantage a political movement could be given: a friendly press, a sympathetic professoriate, a generation of clerks placed in chambers across the federal judiciary, a near monopoly on prestige media, and a country that desperately wanted to believe its institutions were stable. It squandered all of it. Not because the opposition was too clever. Movements face clever opposition. Not because the cases were too hard. The court faces hard cases every term. It squandered it because the gap between what the party told itself about the Constitution and what the Constitution actually says was too vast to bridge. Chuck Schumer on the steps of the Supreme Court in 2020 was the first warning sign. The Senate Majority Leader of the United States, threatening federal judges by name in front of the building where they work. That was the moment. It took the rest of the country a while to catch up, but the reckoning has arrived, and it was, as it turns out, inevitable. You cannot build a political movement on the assumption that the judicial branch exists to ratify your preferences and then act shocked when the judicial branch remembers what it is. Someone always remembers. And the bill, the full accounting of what the modern Democrat Party tried to do to the Supreme Court of the United States and what the Supreme Court has now done to its arguments, is being paid in full, in open court, in published opinions, in the plain language of the Constitution it spent so many years pretending to revere. History will not remember this party the way its supporters hoped. It will remember it the way the evidence demands.